Hello, I'm Molly Monks, a licensed insolvency practitioner at Parker Walsh, and I'm going to be discussing winding up petitions. What are they, what happens, and how does it affect your company? So essentially, if a creditor is owed £750 or more, essentially that's where the company owes someone, it could be a supplier, it could be HMRC, £750 or more, and it's not disputed and you've paid it, the creditor has the right to take action against that company. It may serve a statutory demand on the company, and again, if it's not disputed or it's not paid, then the creditor can obtain a winding up petition, and that is served on the company. So the creditor has to be very serious because they have to pay a deposit, cover legal fees possibly, and the court fees. And that's quite substantial. It can be, it's nearly about £3,000. So the creditor is very serious if they're paying that amount of money to take this action against you. So in turn, you should also take it seriously. So if they've obtained a winding up petition, we know they are serious. And they have to serve it on the company. Now, they can hire a firm to do that on their behalf, but it has to be served on the company. Unfortunately, there are no tricks or loopholes to get out of it by not answering your door or not being available or changing your registered office. Doesn't work like that. Everyone's tried it. It doesn't work. They can sellotape it to your front door if necessary. They can serve it on the receptionist. You don't actually have to be there. So it will get served on you, and it's best not to try any little tricks like that to get out of it. We just need to be responsible and look at it once you've got it and to take action. So once you've been served with the winding up petition, again, get in touch with someone like myself, a licensed insolvency practitioner. We'll be able to advise you on your rights and next steps and also other options that you could take. But say if you do nothing and head in the sand sort of thing, it's eventually, before the hearing, it will be advertised, and it's advertised in the London Gazette. So your suppliers may not find out about it because they might not read the London Gazette, but the bank will, because they have monitoring systems in place that monitor the London Gazette for winding up notices. So they will see that there's a hearing that's outstanding, that's coming up for a winding up petition, and they will protect themselves by freezing your bank account. So this is your company bank account, and it will be frozen. They don't give you notice, it will just be frozen, and that will stop you from trading. So you won't be able to pay wages, you won't be able to pay suppliers, so it has that effect. And then there's the hearing. So unless you send representation by way of a barrister, junior barrister or solicitor or yourself, and again, say you do nothing, then most likely the judge will side with the creditor and the company will enter into compulsory liquidation. So what that means for your company is that the official receiver, which is a government department, it will be their duty to sell the company assets. So that could be plant and machinery, it could be a company vehicle that you drive, it could be tools. It will sell the company's assets and convert them to cash, or it will just use the cash that's already there. The official receiver will take their fee, which is quite substantial. It will repay the creditor's deposit, and whatever's left will go to the creditors. It will be distributed pari passu equally between the creditors. It will also invite you as the director for an interview. You'll have to fill in a pre-interview questionnaire, and then the official receiver will be in touch to arrange an interview to find out essentially what's gone on with the company, what assets are there, what money have you taken out of the company, and sort of what drove a creditor to have to take this action. You know, why was he ignored? Why didn't you pay him? And so all that gets looked at by the official receiver. But there are options that you can do. So as I've said, you need to get in touch with someone like myself as soon as you can. The earlier the better. The longer these things go on, the less chance we have of alternative options for the company. but it could be that we can place the company into a creditor's voluntary liquidation. So that would avoid the hearing, being interviewed and questioned by the official receiver and having them deal with it. It'll be dealt with by someone by myself, and we can get a clear strategy in place in regards to the assets rather than the official receiver dealing with them. And it can also be more beneficial to the creditors, especially the petitioning creditor, because they'll be reassured that actually you're taking action. They don't need to go to the extreme lengths of obtaining a winding up petition, and there might be a better return to the creditors as well, because my fees are typically lower than the official receivers, so it can actually benefit both parties. But each company's situation is unique, and so what I would say is if someone's threatening to issue a stat demand, or they have served a stat demand, if they're threatening to wind the company up, so you've got a petition's been served, there's a hearing set, any of these factors, you need to get in touch with someone like myself, so we can give you that tailored advice. Or it might be that none of that has happened, but you know that you have creditors that you can't afford to pay. It could be HMRC, as we know, they do petition to wind the company up, or it could be a supplier and you can't afford to repay them. In that situation, get in touch with a licensed insolvency practitioner. We're here to help. We can advise you of the options, and we can also give you advice in regards to what happens in a compulsory liquidation. Okay, so I hope that's helped. Any questions, please get in touch. Thank you.